Okay, so let's start talking express terms. So this is what we're doing here. We are going to be identifying the express terms. So by express terms, I mean terms that are expressed somewhere. That definitely includes things that are written down, but it may also include things that are said or things that can be objectively implied from conduct. So there are two, generally we talk about things that are done and said before or leading up into the point in time where a contract is made as being representations. The most famous use of that term that I think lay people usually will understand is the idea of a misrepresentation. So we know under Section 18 of the Australian Consumer Law, used to be Section 52 of the Trade Practices Act, that you must not mislead or deceive in trade or commerce. So misleading statements or misrepresentations as they're referred to is a context of conduct. Here what we're needing to do is work out what representation, what things that are said or done in the negotiation or the lead up to a contract being made, which of those representations are promissory in nature and therefore terms, and which are just made to induce someone into a contract but are not intended to be promises. So there are puffs, opinions, estimates, for example, that might be non-promissory in nature and not terms. So it's unlikely that you will be successful in an action against a soft drink company because the Red Bull did not give you wings. However, if the soft drink company estimated that there were X grams of caffeine in every 100 mils and you turned out to have some sort of tolerance up to X but not over X, it might be a different situation. Promissory terms are clearly the terms that are meant to be binding. They're intended to be relied on. And ultimately, a breach of a promissory term is, or a failure to meet a promissory term, is what gives right to the ability to sue under a contract. So for every promise that is made, that creates an obligation and a corresponding right. So its failure to perform the obligation means that the person who has the corresponding right, not always, but usually actually, it's not always that person, because when you think about the way the rule of privity applies, it might not be that person. But when somebody fails to perform an obligation, then you can sue them. And then, so that's why we need to start classifying what those terms are. So let's talk about puffs. We've spoken about puffs before. Sales puffs are typically advertising talk. They're meant to promote a sale. They exaggerate the qualities of the subject. They're not intended to be taken literally. And ultimately, they have no legal effect if untrue. So it's usually easy to tell what a puff is. Most famous case in relation to this is Carl Hillen's Carbolic Smoke Ball. I guess the large amount of money in relevant dollars could have been a suggestion that it was a ridiculous amount of money, that nobody would seriously have put that amount into the bank to show their sincerity, but ultimately the words that were used suggested they really didn't help this argument that nobody could have taken them seriously. So I'm not going to spend any time on puffs. I'm assuming that we're all pretty comfortable here. So I want to really focus now on the difference between a representation in this term and a representation that is something else, that doesn't have a promissory value. So, how do we work out what a representation is? Understanding that some of them are terms and some of them are not. Often representations will be statements of fact. Sometimes they'll be statements of opinion. So a statement of opinion about a fact, often saying that the person who's making that statement has some knowledge or some reasonable grounds to give the opinion. So let me give you an example that I work with all the time. I work in M&A, financing, usually technology companies. Often we will get an independent expert to come in and value the intellectual property assets, to have a look at the code, to make an assessment about whether it's original or things like that, and to have an estimate of how many hours it would take to put that together and those kind of things. So that the question often arises, does the independent expert promise that their opinion is reliable? And if they do they promise, who do they make that promise to? Do they make that promise to the advisors? Do they make that promise to the person who paid their bill? What happens if they're wrong? Is it a promise or is it just an opinion? So again, think about it from the point of view of you at some future time giving somebody legal advice. Do you promise that you're correct? Or is it advice? You usually promise that you have prepared the advice to the best of your skill and ability and that you have not been negligent in preparing that, but you can't usually promise that it's 100% right. It'll depend on the complexity, it'll depend on a range of different issues, not the least of which is whether your client has told you the truth. A range of different things. So representations are generally, in this context, things that are statements that are made to induce somebody to enter into a contract. If they're intended to be relied on and they become part of the contract, then they will be terms. But they may not be, even if they're intended to be relied on, they might be replaced by the detailed statement in the physical contract itself. So generally, they're not intended to be relied on unless they become a term. And representations that are false, even if they're not a term, they might still give rise to some cause of action, particularly under the Australian consumer law. Actually, I've talked about all of that. Let me get into giving you some examples instead. So, next step here. I've spoken about this really briefly before. Oh gosh, we're already at 7 o'clock. We've got these 3 types of classification of terms. So particularly when a representation is made, a representation that somebody relies on, we need to understand whether that term, well, is that representation a term? If it is a term, is it an essential term? If it's an essential term, is it it will be a condition of the agreement. Is it a warranty? So is it a term that is not essential, but a breach or a failure to meet that term should give rise to damages? Or is it an intermediate or an innominate term? So they are this sort of middling case where you're not quite sure which they are, and these are the ones that are hard to classify, and the consequences are dependent on what the impact of the breach is. So in relation to conditions or essential terms, the key authority here is the Tramways case. This is one of the most often cited cases. It's a 1938 case related to advertisements on the sides of the trams for Luna Park. And so the clause in the contract basically is somewhat vague, but the understanding that Luna Park had was that trams would be running around Melbourne with their ads on the side of it for a certain number of hours every day, every week. And ultimately, there were less hours. So the question became whether Luna Park could terminate this contract or not for a breach of that case. Because it really didn't suffer any damage. It was very difficult to identify what the damages would be. It didn't want damages. It wanted to terminate, find better value for its advertising buck. So this comes from the Chief Justice Gordon at the Times decision. The test of essentiality is whether it appears from the general nature of the contract considered as a whole, or for some particular term or terms, that the promise is of such importance to the promisee that he would not have entered the contract unless he had been assured of a strict or substantial performance of the promise, as the case may be, and this ought to have been apparent to the promisor. So I would be thinking that it is as an essential term of your agreement with RMIT University that your law degree will incorporate all of the requirements, academic requirements, that are necessary for you to apply for practice. I doubt it actually says those words out loud. I've never looked at one of you. But to me, as I look here, you guys are studying law. I'm thinking you want to come out with a JD that meets the education requirements for admission to practice. If you were studying medicine, you would want to make sure that the subjects were of a quality and a standard that would meet your obligations to become a doctor or similarly an engineer. If you're studying an arts degree, it's probably not an essential term because it's not a professional degree in that context. Accounting, you would want to know that you could get to that next stage. Does that make sense? So they're the kind of things that is along the way you recognise that made it sound like it was a true statement. If along the way it turns out that the university is not offering you that, you would be thinking, that's an essential term. I should have the right to terminate, as well as the right to claim damages. I probably shouldn't use examples like that. Intermediate terms are the tricky ones, okay? So intermediate or innominate, as they're sometimes called, are the ones that it's really difficult to classify what they are. Hong Kong fir is the case that your casebook uses, and Kumfutu and sandpine is the other one. So Kumfutu is basically the Australian recognition that this rule applies. And in a nutshell, the rule is if we can't easily classify what kind of term it is, then let's look at what the damage impact is. So if a party breaches, significant damage or damage that where the only real restitution would be to terminate the contract, that might be an appropriate remedy. But when the damage is only small and it doesn't matter, then you shouldn't have a right to terminate. So the consequences of breach should be proportional to the damage itself. Warranty, regardless of the consequences, so even if the consequences are really dire, if it's a warranty, damages are your only consequence.